Good morning, everyone, and welcome to our Live and Learn session today. We've got a really fabulous client of ours that's joined us to go over everything to do with wheels. Her name is Nicola Westcott, and she's from Westcott Wheels. She covers the Bishop Stortford and surrounding areas, and she helps you protect your family's future. So I'm going to hand over to Nikki, and she can explain more about herself.
Thank you very much, Maddie. So hello everyone, I'm Nicola Westcott and I'm a will writer and a non-practicing solicitor. Thought I'd start with a little bit of background about myself because it's always quite nice to get to know where the person who set up the business came from, find out a little bit more about the person who's talking to you. So my family moved back to Bishop Stortford when I was 9, and I went to school here in Bishop Stortford. I went first to Somercroft about 100 years ago, and then I went to Herts and Essex High School. So I'm a local girl at heart. I left school having just missed the grades I was aiming for, and after a bit of persistence managed to get a place at Swansea University to study law and German. And if I can make the slides work, which they now don't want to work. Why won't it go to the next slide? Hold on. Maybe I have to do it manually. Sorry, everyone. Finally, I've worked it. You can see the younger version of myself with one of my very best friends, Rosie. She studied law with me in Swansea. So that photograph was a long time ago. I immersed myself in university life, belonging to such clubs as the Life Saving Club, but I was also somehow convinced to join what's called the Officer Training Corps by my other best friend, Karen, who said you got to go skiing and scuba diving for free. Well, I was wondering about this as I was lying in a muddy ditch under a self-erected shelter that another girl and I had put up in a ditch that had simply filled up with water overnight. Yeah, that wasn't quite as I had planned it. But we did get to go skiing and scuba diving, but that came a little later. And I have got some photographs if this works. So the only photograph I could find of me in my uniform, for some reason, is with a group of students in togas. I don't know why that is. But this was in the day of non-digital photography, so I didn't have many photographs to pick from. There's me scuba diving, and I couldn't resist one with me with the regimental goat. I had a year out in year 3 in Mannheim, Germany, which was a fantastic experience. And having eventually knuckled down to some work in my final year, I left university with my LLB and itchy feet. I managed to convince my now husband, Rob, to apply for a year out teaching English in Japan with me. And amazingly, we both gained a place and were allocated schools in a city about 3 hours north of Tokyo by bullet train called Yamagata. What an amazing year. The people were so nice, and they couldn't do enough for you. Now, again, this was in the days before digital photography, so I have had to steal a couple of pictures from the internet. But Yamagata was situated at the bottom of a dormant volcano. So you can see the crater of the volcano filled with the green water at the bottom of the crater. It was beautiful. And it was also a ski resort in the winter because it got very cold. And as you can see from the top left photograph, the wind and the cold created these over the trees, things that they called the snow monsters of Zao. Zao was the name of the volcano. And you could also sit in hot baths in amongst the snow because the volcano obviously had hot water. They called them onsen, and it really was very beautiful. I also traveled extensively while I was in Japan, seeing Tokyo, Kyoto, Hiroshima, and the most beautiful ice festival in Hokkaido, the northernmost island of Japan, and of course a good deal of skiing. But at some point I had to get back to real life. So we came back in 1999 and I took my legal practice course. I got a training contract with Fladgate Fielder, who are now Fladgate LLP, after a bit of paralegal work there. And I qualified in 2003 into their private client department, which basically is wills, trust and probate. I dealt with a whole range of things during this period, from the preparation of accounts and tax returns, estate management, and as much as setting up more complicated trust structures and managing those trusts on an ongoing basis. So this really is my background. I decided to leave practice following the birth of my son Barney, who you can see there on the right, in 2009. And I set up Westcott Wills in 2012 from my home in the East End of London in order to continue to pursue a career I enjoy, but being able to spend time with the children as well. So to complete the picture, there's Annabelle there on the left. She is now 16. Luke's in the middle, he's 9, and Barney on the right is 14. Oh, and I also have a very long-suffering husband, Rob. And we celebrated 20 years marriage this year. So not to forget him. So enough about me. That's quite enough about me. What about you? I'm wondering how many of you here have a will in place? And if you do, are you confident that it's up to date? Are you aware, for example, that there are rules regarding who inherits your estate in the event that you don't have a will? Where there's a surviving spouse, that surviving spouse will take everything, unless the deceased leaves children, in which case those children will take a share or a proportion with the surviving spouse. So I want to take a look at an example to help illustrate the point. I've got Mr. and Mrs. No Will. They are, as their name suggests, with no will. Mr. No Will has his own children from a previous relationship, A and B. And they have their own children. Mrs. No Will has no children. Does anyone know what amount of money Mrs. No Will would be entitled to from Mr. No Will's estate if he died? I'm going to tell you the answer to that. Under the law of intestacy, Mrs. No Will gets £270,000. So there's a statutory legacy of £270,000 that the surviving spouse will get if their husband or wife dies. The remainder of his estate will be divided into 2 shares, though. So Mrs. No Will get half of that remaining share, and Mr. No Will's children, A and B, will get the other half. And if either of those have died before Mr. No Will, then their children will get their share on trust until they're 18. Now, I think most married couples would prefer their spouse to get the bulk, if not all, of their estate on death, without any added complications. And because for many people, their main asset is their family home. So you can see how this would cause potential issues. So for married couples, you can already see the importance of having a will which sets out exactly who takes the assets. But where there is no surviving spouse, assets go in the first instance to children of the deceased. And again, if those children are under 18, they're held on special trusts. And after that, there's a strict order, which is called the order of intestacy. So first of all, it's children, then it's parents, equally if they're both alive. But if there are no parents, it would go then to brothers and sisters, then half brothers and sisters, grandparents, uncles and aunts. And you can see at the end, if there are no surviving relatives, everything goes to the crown. So this isn't a desirable outcome. So here, now you can see how important it is to get your will in place to avoid things going in a way that you wouldn't want them to. And even if you're single, it's really important to have a will in place, because it's the only way that you can ensure that who you want to get your estate does. And also a very important additional point is guardianship for children. It's the only way to make sure that your children are looked after by the people who you choose, and not necessarily, and they don't get spat out into the system and taken into the courts. I also asked whether everyone's will here was up to date. So, for example, are you aware that there are a certain number of life events which revoke or change a will? So the most important one of these is marriage. So if you get married, it's very important to understand that marriage revokes a will. So if you already have a will before you get married, if you get married, you must do a new will, because your old will be revoked. Other situations where you may need to review your will: divorce, separation, birth of children or grandchildren, a new relationship, death of a spouse or partner, death of current executors, or a substantial change in value of your estate, for example, if you won the lottery. So all very good reasons why you should just review your will. Don't just do a will and leave it sitting there for 20 years and think it's still going to be as good as when you wrote it. So I've got a few more scenarios to set out to you to show you how important it is to think about wills and what situations you might need to review your will. So I've got a Mr. X and a Mrs. Y. Mr. X and Mrs. Y are not married, but Mr. X was married to Mrs. X. Mr. X has his own children, A and B. Mrs. Y has her own children, C and D. Mrs. X died on the 30th of November 2018. Mr. and Mrs. X had a will dated 31st of August 2015, leaving everything to each other and then to A and B. Mr. X starts a relationship with Mrs. Y on the 19th of December 2020. Mr. X doesn't change his will. Mr. X dies on the 7th of May 2022. I want to know what happens. Basically, everything will go to Mr. X's children, A and B. So just having a look back at the scenario, remind you, Mr. X had a will with Mrs. X. He inherited everything from Mrs. X, but he didn't change his will when he started his relationship. He's not married to Mrs. Y. He hasn't changed his old will. Because he's not married, his will isn't revoked. His old will said everything to Mrs. X. She's not around. So if she's not around, everything goes to the children. So everything goes to A and B. Mrs. Y will get nothing. C and D will get nothing. This may be what Mr. X would have wanted. He may just want his own children to inherit his money, but it may not. He should have thought about a new will if he wanted to include Mrs. Y and her family to any extent. Same scenario, but this time Mr. X and Mrs. Y get married on the 2nd of July 2021. Mrs. Y has no will. On the 11th of October 2021, Mr. X and Mrs. Y sell their respective houses to invest in joint property as joint tenants. In addition, Mrs. Y has £100,000 of cash assets in her sole name. Mrs. Y dies on the 1st of May 2022. Let's look at what happens here. I just want to tell you what the difference is between joint tenants and tenants in common first. So joint tenants means that a property will pass automatically to the survivor on death, the surviving joint tenant. Tenants in common means that each owner has a separate share, and that can be in different proportions. So each share would pass under the respective owner's will if they have one. So going back to the scenario, just to remind you, it's Mrs. Y who's died. Neither of them have a will, remember, because Mr. X did have a will, but he's married Mrs. Y, so that will got revoked. But Mrs. Y doesn't have a will anyway. They're joint tenants. So the first thing that happens is that Mr. X takes the house outright. Because they hold as joint tenants, it's nothing to do with his will. Even if he had a will, the house passes automatically to him. He will also take the £100,000 cash assets, as he would be entitled to the £270,000 legacy that I mentioned that the surviving spouse gets. He would also be entitled, if her estate was bigger, to half of any balance above £270,000. Now, as I said, Mr. X's previous will was revoked by his marriage to Mrs. Y. Therefore, if he died in quick succession, all their joint assets, if he died in quick succession without redoing his will, all their joint assets which he inherited would pass to A and B, remember, his children, under the law of intestacy, and C and D will get nothing. So again, you can see how important it is as situations change to keep your will updated. Finally, I just want to talk to you a little bit about protection of the bloodline. I want to come back briefly to this because this might be something to think about if you're married and you've just got a very basic will at the moment. So I've got one more scenario for you. You'll be pleased to hear it. This is the last of the scenarios. We've got the same people to make it easy for you. Mr. and Mrs. X had wills leaving everything to each other and then to their children, as you remember. Mr. X received all of Mrs. X's assets when she died. Mrs. Y likes a good time and nice holidays, so Mr. X spends a lot of Mrs. X's money on this. and C has a drugs problem. Mrs. Y convinces Mr. X to spend the rest of Mrs. X's money on sending C to rehab. So you can see here that A and B will lose out because Mr. X has the money outright from Mrs. X. So he can do whatever he likes with it, and he's come under pressure from this new relationship to give money away, and so that's what he's done. A and B losing out. If he marries Mrs. Y, is he married in this situation? I've now lost track. But if he marries Mrs. Y, that's another way that assets can go away from his children. So I see this happen a lot. So this is a really big issue. But it's possible to have a very simple trust in your will to protect assets for your direct bloodline, therefore avoiding this issue in the illustration. So the main beneficiary of the trust would be your surviving spouse or partner, but the eventual beneficiaries would be your children. And you can include other trusts in a will to protect your children against potential divorce or bankruptcy, for example. And another advantage of trust in a will, if established for legitimate wealth preservation reasons, is if the survivor ever went into long-term care, the home can't be taken away to pay for those care home fees. Now, the trustees of the trust can rent out the house to provide money to pay towards the care home fees, but they can't be forced to sell the house. So there are many reasons why you might want to consider updating your will to add a trust to it, if it's only a very basic will. That's the end of my presentation. If you have any questions, I think you can direct them to, well, I think Madison's got some information about that. Thank you very much for listening. Nicola Westcott, Westcott Wills, protecting your family's future.
Lovely. Thank you so much, Nicola. That was really helpful. Lots of information there. And yeah, definitely a lot of food for thought for many people. If anyone does have any questions, feel free to either send them over to us and we can share them with Nicola, or if not, in the description of this video is going to have all of Nicola's socials and her contact information. So if you need any help with your will, you'll know where to get in touch with her. But thank you very much for taking time out to listen to this.
Thank you for listening.